we are very delighted to have with us today a gentleman who's been out there doing the stuff, and it's a great an honour and privilege to have Michael Doherty. Thank you very much, Michael.
Thank you, Roger. So, good afternoon, everybody. I'd just like to say I'm usually dealing in a court with just a judge and stuff, and there's quite a lot of you, so I'm really nervous. But and it's good to see a lot of you, and thank you very much, Roger, for inviting me down to talk about this. I guess, I don't know, this is sort of private prosecutions. I mean, John's covered off a lot of my material, but I'll sort of skip through it. But private prosecutions, I think I think we all know there's massive corruption in the UK. Nothing's been done about it, and I've known about this right to privately prosecute for a long time myself, just something I knew, and I decided I came involved in corruption, police corruption, and some other corruption, and I decided I'm going to do something about it. I'm going to stand up and do something. So and I think it's a massive, it's not the only answer, but it's one of, I think it's a big, and it's going to be a very significant factor in the coming years. And I think the government, the powers that be, know this. And I think our forefathers, whoever, that we gave us this right of private prosecution, they're very, very, foresightful. So I'm Michael Doherty. I've started an organisation called Justice Now, and Campaign for Justice. There were two different campaigns, which are still ongoing for different reasons. Okay, I have to say I'm really, really lucky. I've got loads of, it's all over the internet. Even the mainstream media have followed and started broadcasting the stuff that I'm doing. I think because they don't have any option. It's in the courts, not behind closed doors. It's public, and they're all following it. I've been on BBC and the whole lot. And again, there are some good journalists out there who are prepared to cover this thing. There's Guardian article and some really good stuff. So if you Google my name, you'll come up with it. I think it's really important. Most of us are normal people, and I just wanted to just quickly say, where did I come from? Yeah, some moron was putting stuff on Facebook the other day. I know I'm 41 years old, and it shouldn't be like that on Facebook, but it's a very good networking tool. Saying I was MI5 and nonsense like this. I guess they're getting worried and they're trying to sort of detract who you are and stuff like that. What?
I think you meant MI5.
Yeah, probably. Well, I'm actually a trained aircraft engineer. I used to work for British Airways and working on Concorde and long-haul fleet of British Airways. And I did that for like 18 years. Did some other things inside British Airways as well. But then all this stuff started happening to my life, and my life took a completely different course, not through my own choosing. I was involved in trade unions when I was at work, because I stupidly, as a young man, believed that trade unions were there to help us all. And I used to go out and do things and try and help my colleagues at work and stuff like that. So it's always been something that's in me to do that. I'll come to one of the... Interestingly, the trade unions feature in my private prosecutions, because one of the things that we have to remember is when we're taking the state to court in the criminal courts, where this is the real accountability is, because this is them personally standing to go to jail, to get a criminal record. The public purse is also paying for their defence. Now, they've got massive cutbacks on, if you end up in the courts, they've got massive cutbacks on the criminal legal aid support for you, and you'll have to pay for your own defence. But if they're in court, they get public funding through the back door. But interestingly, one of the trade unions, the Commercial Service Union, the Public Commercial Service Union, is actually funding one of the defendants, police defendants, in one of the private prosecutions. Now, it's not in their membership benefits. I don't think that they'd extend it to all of their members if they got into criminal liability issues. But this particular individual has union backing in the criminal courts, which is quite extraordinary. So, my concerns about union. Perseverance. I think, one thing you've got to get in heaps with all of this is perseverance. And I did something, again, back in, there's my British Airways running vest. I did 2 marathons in 2 days. I ran London, and then I jumped on a plane, not very eco-friendly, but I jumped on a plane, went to Boston, and had about 3 hours sleep and ran the Boston Marathon. And I did them in like 3 hours. Not both of them. 3 hours, 6. Yeah. That's my dog who used to come out with me. So, you know, I've done these marathons. And I think you need perseverance. I got divorced, yeah, you know, it happens and stuff like that. I've got a beautiful daughter, and I think this is my first foray into the courts. I realised really quickly that the solicitors were not up to it. I don't know if anyone's been through divorce and stuff like that. The solicitors are really not up to it, so I thought I'm going to do this myself, yeah. I decided to do it myself, and bizarrely, I think, I don't know, I'm quite proud of it, and I got, you won't be able to read it, but in 2000 and whatever it was, 2003, I got residency of my daughter, yeah, at 7 years old, in a thing. You know, my ex-wife's not a drug addict or anything like that. There's nothing bizarre about her, but the court gave residency to me, which you know, as a father, I think was quite privileged, because most fathers get a much more rough deal in divorces, and I was doing it myself. No barristers. I was up against barristers, but they weren't really worth the salt that they were being paid, for sure. So you know, I had dealings with courts. I thought, you know, they're not too. In 2007, I had a run-in with the police. Okay, so like, it was like it was a bit Jeremy Kyle, but hey, there was an incident at my house. I called the police to remove someone from my property, and what happened was the police officer went off. It was actually with my ex-wife. Went off with her for about 4 hours. I don't know what happened in that 4 hours, but he came back into my house and forced an entry into my house at 11 o'clock at night. My then wife was eight months pregnant at the time, and this officer threatened to assault me, to arrest me. He forced an entry into my house at 11 o'clock at night when I told him, look, mate, you know, thanks very much, you've sorted the breach of peace out, you've done your job, good night to you, I'm going to bed. It went through the police, my first experience of the police complaint system, which if you come up against it, the IPCC, utter shower, and I'll talk to you a bit more about that in a bit. But they exonerated him, yeah. Even though that night at 4 o'clock in the morning I got a call from an inspector apologising profusely for the behaviour of his officer, and he's apologised and told everything about what's gone on, and next thing, when it goes into complaint, you're a complete liar, and it didn't happen, he never came into your house, and blah, blah, blah. But the IPCC, because after they went through their investigation, I said, why don't you pull the 999 recording that I made asking for your officer to be removed from my house, which will show that I'm not a liar. They did that, and they overturned the decision in March 2008 in relation to this officer. And again, it's all standard MO. The officer retired, and I'm no police hater. I like John Hurst, even though he's covered off most of my stuff. But yeah, the standard MO is if they're up for disciplinary, they retire. They avoid disciplinary, then they'll go in some other police force somewhere else and rejoin somewhere else, and you don't know. Simon Harwood is a prime example, the guy who killed Ian Tomlinson. Yeah, I mean, utter, can I use the word shitbag? Disciplinary, you know, record, which is quite extraordinary, and even the IPCC said how on earth he got back into the Metropolitan Police is beyond even that dodgy organisation. But yeah, so that's what they do, they retired. It's all the patterns, the same standard MO, all of these things. So yeah, he retires to avoid disciplinary. So I'm going to let you listen to a 999 recording, just break it up a bit, of me calling the police to ask them to move the policeman from my house, okay? But you have to listen to the end of it. If you haven't seen it, it's on YouTube, okay? No? Why is he not working? Shall I get it? Shall I pull it up on a? Let me pull it up. If it's not bedded for some reason. I'll do it that way. I've changed my number.
Because I'm not giving you anything, because I think you're very rude, and I've asked you to get out of my property. Hello, please. I'm not leaving you, I've got a child. Hello, please. Hello, please. I've got a police officer who is refusing to get his foot out of my door. I've asked him to leave my property, and he is refusing. Can you please get a alarm police car down here?
What? To tell the police?
29 Mill Road, West Drayton.
What? To tell the police officer?
He's asking for property from my address, which he's not entitled to, and I'm asking him to leave. His badge number is XH284.
Right. Okay, he has a normal right.
He does not have a right to stand on my property,
Yes, he does.
and I would like him to remove himself from my property.
But he's not going to do that, and as long as he's aggravated, all it will do...
Can you get another police car down here, please?
I'll tell you what, I'll sort the police car down.
Can you get out of my property first?
He's not going to get out of your property.
Yes, he will get out. What do you mean he won't get out of my property?
Because he has a right.
No, he does not have a right to stand in my property.
Yes, he does.
No, he doesn't.
And that's it.
If you get out of my door, I will consider what I'm going to do. Can you get out of my...
No, because you close the door in my face.
What do you mean I close the door in your face?
You close the door
Please
in my
get
face.
out of my property.
As long as the door stays open.
No, the door is not staying. It's my door. Please get out of my property. Can you get another police car down here, please?
I'll tell you what I'll do, sir. I'll have the police car down to come and assist my colleague. Certainly not to
Good,
assist
thank you very much.
Right, thank you. Bye-bye.
Did you get that? I don't know. Let's get back to that.
Just out of curiosity, was the phone operator, was she disciplined for calling you that word?
Yeah, I'll just give you I didn't get the tape till quite a long time afterwards. And what they did, they came to me and said, it was all very nicey, officer, and they said, well, you're not really after you're not really making a complaint about the phone operator, are you? You're more concentrating on the officer, aren't you? We're going to concentrate on that, yeah? Because, I know she didn't send the police and stuff like that, but, and I thought, I haven't heard that. And she didn't get disciplined. So that's just...
Out of curiosity, did it come out that woman, or the operator, should I say, was a police officer's wife?
No idea. Don't know.
It'd been interesting to find out who she was.
Yeah? Well, I've got her name somewhere. I know it's somewhere in my paperwork and stuff like that about her, but, that's, there's a police officer. Just the thing about the clothes, basically what happened is, my daughter was then 13 at the time, and obviously first daughter, problem starts 13's behaviour, and she'd gone off to her mum's, yeah, and there was some shenanigans going on with her mum. And the policeman came back at 11 o'clock at night, and I've got an enforced residency order that she must live at my house, yeah? And I'm certainly 100% sure if it was a woman there saying that the guy's taking the daughter off, they would be, get the daughter, bring her back to the mother. But as a guy, I don't know, he just decided he's not going to do that, and he's going to come, and he'd come with a whole list of staff, and he was performing some sort of removal service. And I said, look, I'll sort it out in the morning, thank you very much. But anyway, they threatened to arrest me and stuff like that. But he was disciplined. He left to Barry Hargreaves. That was March 2008. There was as soon as I made a complaint, again, standard MO, I started coming under attack, from the police and various other places. I discovered really sadly that my daughter, so a few months later, problems continuing with my daughter. I thought, I respect her privacy. I thought I'd look at her PC, and I discovered very sadly that she was being groomed over the internet, by more of a paedophile or whatever. The material is no one through all of this stuff has suggested this material is not severe. The person was getting her to send images and video of herself across the internet and all of this stuff, and the documents I found was talking about kidnapping her. I was talking about coming to meet in a hotel, and very, very sort of highly sexually explicit. Not particularly from her, but from this particular individual. So I think I've had a whole load of stuff I won't go into with the police. I think, okay, they're not going to mess about when children are involved. Oh, how wrong I was. But I reported to the Metropolitan Police, and I hand over the document of this material to them. The PC still remains in my home, and I hand it over to the police. It became an investigation with the Metropolitan Police Sapphire Unit, which is notoriously failed women and children in London. You can look up Kirk Reed, John Warboy. Recently there's an officer who's been convicted in Southwark Crown Court for forging letters to victims of rape saying that the CPS have decided to drop charges. So there I was, back in August 2008, very concerned father for my daughter, reported this to the police. They didn't even bother coming anywhere near me. They didn't bother come back, collect the evidence or anything like that. 2 weeks later, I call up and say, look, there's something going on with your officers. Can I get some senior officer to sort this out and move it to a different borough because there's something going on, yeah? So I call, and I have to be very careful because these are criminal trials. I called twice, 2 calls on the 1st of September 2008. One of them's 2 minutes to 5. Well, it wasn't 2 calls actually. There was 1 call, 2 minutes to 5, and I get a voice message back from a particular individual. I get raided by the Metropolitan Police. 6:30, round about 6:30 on the 4th of September 2008. I get my home raided by, first off, 2 plainclothes Metropolitan Police officers. They say they were from something called the Violence Against the Person Unit. Sergeant Gareth Blackburn, Detective Stephen MacDonald. I was taken unlawfully, an unlawful entry to my house. I was assaulted in my house, and they actually took me naked from my home, in handcuffs. And by the end of the whole thing, there was police cars all up the road in my house. Obviously, my neighbours were all watching, and blah blah blah. So, obviously, very humiliating and not a nice thing to happen. But I can't talk too much about it, so I'm gonna. Right, just film the entry. I'm not going to show you that, but I filmed. One thing that's really holding people to account is our access to the evidence. Much of the evidence is now in our possession, so when John's talking about doing investigations and stuff like that, sometimes we don't need to do investigations, sometimes we already have the evidence. In my case, I videoed the entry. I had the technologies in my pocket. When the police officers came, I started filming them, yeah, what was going on in my house, and I won't talk about it, but some people probably here have seen it because it was on the internet for some time, but I've taken it down now to criminal trials on. It's pretty extreme. There's lots of articles you'll see about it, how people talk about it, what happened in my house. When I was initially arrested for harassment, Section 2. If I ever managed to get into any position of power, I would remove that act from Parliament. I don't think it's a good law. It is so widely drafted. It's, someone was allegedly upset by something. And then the truth of it is, I think that they knew these times were coming. They put it in 1994, I think. Correct me if I'm wrong, John, because you've got a brain for these things. But they put it in 1994. They knew these things were coming. They knew that you're going to get annoyed or concerned about your council, your police, and if you call them up, you're harassing and you'll be fined. There's countless cases now across the country where the Harassment Act is used to shut people up. Yeah, criminalise them and shut them up. Well, anyway, I get arrested for harassing my ex-wife. Okay, the nutshell of the allegations of harassing her is that I called her from sometime at the beginning of August, sometime up to the 31st of August. I was calling her and asking her to call me. No conversations or anything like that. Now, bearing in mind the police knew that I had reported to them concerns about our daughter, it would be quite natural that I would want to tell my ex-wife that our daughter is in trouble and we need to do something for her. But anyway, they don't think so. They decided that they're going to, instead of investigating the child grooming, the sexual abuse of my daughter, they're going to come and target me, which is, again, standard MO. This is what happens all the time after time after time. Victims, people who speak out, they get attacked. So within 15 minutes of getting into the police station, I get arrested for harassing my child's grandfather. And also, I was arrested, and it's there in the documents, I was arrested for harassment of a member of the Metropolitan Police, which I'm sure John will tell me is completely and utterly unlawful even from a start, because I can't harass a member of the Metropolitan Police because there's at least 56,000 of them. It'd be like saying you're harassing a member of society, all 7 million of you. Maybe I am, I don't know. But yeah, they didn't even have a name of a person, yeah, because obviously they hadn't concocted up what they were going to do. So I had no interviews about this alleged there was no questions for me on interview about this because they had nothing to ask me about, but they so desperate to get me in the morning. And I was bailed on mad bail conditions. My bail conditions were, I think you might think that this was deliberate to shut me up, you may not contact the Metropolitan Police unless it's an emergency when you must use the 999 system. So if anyone knows about what an emergency, how they class an emergency, it means, for example, the person is on the scene. For example, if I came home and my house was burgled and the person's gone, I'm not allowed to call the police because that is not classed as an emergency. It would have broke my bail conditions. Although some people in here, like Guy Taylor, would say that police bail means Jack wherever he is. Yeah? But anyway. I go to trial in HENDON, and something Roger started at the beginning of it said about the beginning is there is massive corruption in the courts, okay? And I can tell you there is massive corruption in the courts, massive corruption in the courts, massive provable corruption in the courts, and this bit isn't under criminal trial, so I'm quite happy to tell you about it. My offences were allegedly happened in Uxbridge, okay, so it's within the local government, local justice area for Uxbridge magistrates, okay. The victims live there, alleged victims live there, the alleged perpetrator, me, lives there, so jurisdiction for that offence is in the local justice area of Uxbridge Magistrates Court. Being a bit green of all this is the first time I've been in court. I don't know all this stuff. Suddenly, my case gets moved. It gets moved all the way across to North London. So I ask questions. Well, why is my case being moved? Oh, we don't know. We don't know. But you just go to HENDON. So I go to HENDON and have my trial. There's no possibility I could be convicted because it was complete nonsense, and I had irrefutable evidence to show that what was being said about me just didn't happen. But the court clerk in the case was an ex-police officer. They'd moved my case, an ex-Metropolitan Police officer, they realised that they were in trouble with this case, and they moved my case from Uxbridge by no order of the court. There was no magistrate ordered the case to be moved over to a court, and if anyone knows anything about magistrates' courts, which I'm sure many of you do, the person who controls the court case, and there's been lots of papers on it, is the court clerk. Not lay magistrates, the clerk runs the court. He tells the magistrates what to do. He or she is the kiddie in the court, yeah? Now, this clearly, even looking at it on face, justice must be seen to be done. A police officer, when the key witness in the case was a police officer, there's clear questions of conflict of interest, I would suggest. And the way he behaved in the case was... Now, that's currently under investigation by the Director of Her Majesty's Court Services. I won't bother mentioning the guy's name. I won't bother mentioning how I found out that the guy is a police officer. But what I will say is that within all of these organisations, there are decent people. And they see injustices going on, and people will give you information about things. But you can do it. We went into, after I was acquitted, went to an IPCC managed investigation. They reported back and said, no problem, everything's okay. No one done anything wrong in the police, it's all okay. Well, I know it's not okay, and I think when injustice happens to you, you know in there what's going on, yeah? And I think in Lady Hale in Gujarat, the case, the Supreme Court case, in fact, that's one of the things she was saying. You know, the victim knows they are a victim of crime, yeah? Now, the IPCC, which is a charlatan organisation, set up clearly, it talks about to maintain confidence in the police. Well, that can be done one of two ways. It can say nothing's wrong. Or everyone go back to sleep. Mr. Doherty or Mr. whoever is made it all up, or it didn't really happen, everything's good. Well, it wasn't. I threatened a judicial review on relation to the police officers coming to my house. It was blatant that they entered my house unlawfully. I did the work myself. If I'd listened to one solicitor on the way on this road, I wouldn't have got to where I got to. Do it yourself. I listened, I researched myself, and I found out that actually, no, these officers had entered my house unlawfully, provably so. So I threatened them with judicial review on that aspect of the case. I always knew that the private prosecution, I would do a private prosecution. I knew from the beginning, I knew they'd cover up. But I wanted to let them see what happens, their system. Let's see what you're going to do with this, with blatant evidence. They back off the IPCC and say, okay, they entered your house unlawfully. We're sending them on retraining for their powers of entry. And they said that the matter of what happened in your house is not a matter for us, it's a matter for a court. Well, what are you there for then? What were you there for? Threaten them with judicial review. Okay, so let's get up to... So I began preparations for a private prosecution. George Monbiot is part of that Twitter thing where he's been making allegedly some allegations, which he apologised for. But, you know, I have to give credit to that bloke. You know, he wrote an article on something which, you know, the system is obviously intent on covering up. Yeah, he put it in The Guardian, and it's called "Justice is Impossible If We Cannot Trust the Police to Tell the Truth." How true is that now, when we've got Hillsborough, yeah, and you know, countless times, and it's a discredit not only to members of the public, but it's a discredit to the police themselves, because what's happening is now juries are not convicting people when they're relying on police evidence, because people don't trust police officers anymore. And it's becoming a prevalent problem in society that we can't trust them. They're lying all the time. They cover up for themselves. What can you do? It's a very, very good article. It talks about John Charles de Menzies, Ian Tomlinson, I think touches on Leveson, but it's prior to Leveson, News of the World scandal and stuff like that. And then it goes into my story. It says you don't have to be rich, dead or famous to come up against police things. So, yeah, read that article. It's very, very good. After that article was done, I started the Stephen Lawrence case. I understand it was the first private prosecution in 100 years. So we obviously all went to sleep. And I think it's for a number of reasons. Again, Roger touched on it. The fact that the internet is now about, yeah, means that we can access information, we can see, we can connect with each other and stuff like that. I don't know what their intention about letting us have this technology, but it's very good for us. We can research, we can contact other people, we can get advice very easy from other people and stuff like that. And we can find out about these. So people are finding out that I'm doing a private prosecution and that I'm a normal bloke, I can do it. Well, you can do it too. And I think that's very, very important that you can do it. If I can even inspire a few people to start doing private prosecutions to right an injustice, then I've done my job. So they were far and few between, and I think that was in 1995, wasn't it, Stephen Lawrence trial, which was done by Michael Mansfield. Web of Lies article, okay, another really, really good journalist. Just to go back to the grooming investigation, and I think this is very important to touch on. Again, it touched on the good people in the system, because the IPCC initially upheld the judgment about what I was saying, that there was something wrong with this grooming investigation. She's a barrister, very well-connected lady, looked at the evidence of the police and said the police, Metropolitan Police, were negligent in that investigation into the grooming of your child. And I've got the report, and clearly she refused to allow that report to be binned. And then they reversed it. They got someone else to come along and write a new report with lies, yeah, which is this web of lies. So the IPCC investigator who sided and said, and she didn't just do this off her own back. She got advice of a guy called Andy Ryden, who is apparently worked for I've been told, used to work for the Met Police paedophile team. And he wrote a 2-page report on the police investigation, saying that some of his words was that they failed to safeguard the children involved. It wasn't just my daughter. Of course, paedophiles, they like to cast their net far and wide and see what they drag in. I know of other children who were involved in these conversations that I discovered. So, that they failed to safeguard the children involved. She wrote a report upholding the judgment. Article was published, Web of Lies, and the police that article went up. They didn't deny it. They've lied about the investigation. And the paedophile, the gang, whatever, remains at large, abusing other people's lives and stuff like that. You know, that's the report. You can't read it, but obviously that's her report. That's Patricia. I won't say your name. That's her report. Who thinks she came under investigation by the IPCC, and they tried to, it appears, to get rid of her for saying that she was incompetent. So whistleblowers, people who stand up, they're going to become. You know, this is all standard MO stuff. You know, this is what they do. You stand up, you speak out, we're coming for you next. So that's the article, Web of Lies. You can, it's not on the internet, but I think it's on my Facebook because it's a private eye article, so it's behind a firewall. Okay, a trial started in April 2011. Okay, this is how much they don't want these things going. April 2011, I walk into a court and I say, Mr. Magistrate or District Judge, I'd like to lay information, and I'd prepared it all up, and it was an extraordinary, it was in Luton Magistrates Court, and I have a lot of respect to Luton Magistrates Court and its staff. The whole court came in. They'd never seen a private prosecutor, didn't know what was going on. The judge knew what he was doing. the whole court came in. Duty solicitors, everybody came. It was a Friday afternoon. I said my piece about why I wanted to start this private prosecution on the evidence that I've got. And when I came out from it, the people who were in the court actually said what you were saying in there was quite inspiring. In fact, the duty solicitor who was there at the time said, after 20 years working in this job as a criminal defence lawyer, I understand my job now. So. And he remains, like other people, following my story. As soon as that started, the IPCC didn't want anything to do with me. If anyone's had any dealings with them, no matter how serious it is, your brother's dead, serious police corruption, they won't come near you. They'll just go off and do something, year later, chuck you a report. They don't even tell you it's coming, it just lands on the mat. Oh, everyone's exonerated. Wonderful, thanks very much, Mr. IPCC. As soon as the private prosecution started, I got a call from my MP. Deborah Glass wants to meet you in Parliament. So I thought, okay, let's go and see what she's got to say. Now, clearly now, it looks like, she's like trying to sound out what nerve's going on now. Because these prosecutions, they said nothing's wrong. So why have I got a criminal prosecution running? So I went into IPCC and I sat down with her for about an hour and a half. Deborah Glass, who's the deputy chair of the IPCC. She was a person who's figured in the recent Panorama programme, which I had some input into. I sat with her and one of her honchos, and she's deputy chair and commissioner of the IPCC. And when I'd set out to her the failings of the IPCC in my case, she stated, on record, because I was taping it, and I'd recommend you tape everything you do, that the IPCC is not very effective. This person is a commissioner of the IPCC for the last, I think, 12 years. Now, I've got from Freedom of Information that she's never brought this up with the IPCC at a director level, but she told me in a private meeting in Parliament, and you can listen to the tape in a second of it, and yeah, it's not very effective.
No, it was never supposed to be.
Well, exactly. So what about all the people who've suffered police corruption in the last, well, that's been going on for 8 years. You telling us now 8 years later it's not very effective. This tape now, there's been some big change. Well, the sound, making sounds like they're doing change. It probably won't work for some. Okay.
Because one of the things that I do absolutely accept is that the police complaint system is not very effective. Because one of the things that I do absolutely accept is that the police complaint system is not very effective.
When that came out, because I obviously, that's good. That's in the bag. When it sort of came out and I circulated around to the media and stuff like that about it, they sent me a letter saying, "You're a terribly naughty boy, Mr. Doherty, and we're going to tell your MP on you." Okay. Oh dear. Yeah, I don't know who they tell things to, but they told my MP that he was terribly naughty and he was recording the meeting that we were in. He didn't seem too interested. That particular story was picked up by The Independent and the Bureau of Investigative Journalists. In February 2010, police dog admit system was ineffective, yeah? So, if you've been to them, I think you ought to go back there and ask them. Right, okay, private prosecution. Okay, we'll go on to... Okay. Okay. This is a good one for you, John. He covered most of my stuff. Private criminal prosecution. So in 1885, the legal historian Maitland wrote, "To speak of the English system as one of private prosecutions is misleading. It is we who have public prosecutions, for any one of the public may prosecute. Abroad, they have state prosecutions or official prosecutions." So any restriction on that right of the public to initiate or prosecute would be an interference with the long-standing English law system. Maitland has been quoted as being the father of the historic father of English, or historian of the English legal system. So he's an eminent guy, yeah? He knew it. And I don't like using the word private prosecutions because every prosecution is in the name of the Crown. Yeah? It's always RV someone. They try, when we go there, they say, it's Michael Doherty versus blah, blah, blah. No, it's not. But they keep wanting to write my name on the paper. No, it's not. It's RV. I just happen to be the victim and prosecutor here. I am not prosecuting in my name, okay? Civil matters are between me and that person, but criminal prosecution is between them and the laws of this country. The king, the queen. Okay. I'm going to go through it. So the historic principles, okay, before paid professionals, okay, it's a duty, your duty in society to deal with criminal conduct amongst us, yeah? If you know, your neighbour's stealing something off you are supposed to go to the court and you would take them to court. You are the witnesses, you bring the prosecution. This is before we had all these barristers and solicitors who have obviously monopolised the system for themselves. So private individuals were called upon to prosecute in the criminal courts. And it was until the late 19th century that virtually all prosecutions were brought by private individuals or families or groups that had got together to administer prosecutions, criminal prosecutions. I think scrap this private prosecution name. It's criminal prosecutions. That's all it is. It's criminal prosecutions. It's not, they try and differentiate. Oh, this is a public one and this is a private one. And going back to what Maitland said about these other countries have state-controlled prosecutions. This is so very true. Why should the state be the person who monopolises the criminal courts? Yeah? This is the sort of system that you would have in some despot country where the state is the only one who can initiate criminal prosecutions. No. We should have the right to do this, yeah? Because when it comes to the state, when they start behaving in a criminal manner, how the hell are we going to be able to get justice if we don't have access into the criminal courts? Which is what I'll come on to. So, mid-1700s, paid lawyers began to appear for those who could afford it, common interest groups, and I've already said that, but they're always carried on in the name of the king. So it's not private prosecutions. Nolly, prosecutor, come on. Okay, so Attorney General has always retained this royal prerogative, different from a prerogative thing of pardon. And last use of it is very, very rarely used. This prerogative was 1954. There was a case, a murder case, which there was suspected political interference that the Attorney General used that to shut down a case. Very, very rarely exercised. So we come to, okay, police as prosecutor. John's already touched on that. The police, right up until 1985, until the CPS were created, the Director of Public Prosecutions, the police were doing all the prosecutions, and we had, off the back of things like Guildford 4 and Birmingham 6 and other injustices, there came a clear need to say, look, the police can't be the whole system, yeah, because and there's other natural things, where a police officer has pursued a case all the way to the end, he's going to be focused, he wants to get a prosecution, and he'll want to do it. So it was right the state separated these powers out. The police do investigation, some other body does the prosecution. And that's what happened. But they were still operating only on the same level as a member of the public who's got the right to walk in and ask for a summons from the court. They're using the same power. State prosecutors, okay, Prosecution Offences Act 1879 established the Director of Public Prosecution, but they still didn't do prosecution. It was only very rare and serious cases that they would take on. And it maintained this right of private citizens to prosecute, but nothing is actual interfere with the right of any person to institute, undertake or carry on any criminal proceeding. So it's just affirming what exists in law. 1908 repealed this, that section, and it's talked about the Director of Public Prosecutions being able to take over those prosecutions at any stage if he thinks fit, yeah? So this is the start of the state now wanting to put its feelers out and take that right off us. Okay, strength of evidence. Now, there starts to be a focus on strength of evidence. How strong is the evidence in the case? And, okay. So at what point does the DPP step in and prevent this prosecution from going ahead? When you want to issue a summons, all you have to establish to get the summons issued is a prima facie case. Okay? In the courts, they'll talk about, on a Galbraith test, a case to answer. But at first, you just have to show the prima facie case to go. This is a Galbraith test, which I'll put out and I'll read out for you. I've been through this. We've had a dismissal here in one of my cases, which I passed this hurdle. And it says, where a judge comes to the conclusion that the prosecution evidence, taken at its highest, is such that the jury properly directed could not properly convict upon it, it is his duty, upon a submission being made, to stop the case. But where, however, the prosecution evidence is of such strength or weakness depends on the view to be taken of a witness's reliability or other matters, which are generally speaking within the province of the jury, and where one possible view of the facts there is evidence upon which a jury could properly come to the conclusion that the defendant is guilty, then a judge should allow that matter to go to a jury, to trial, which I don't disagree with. You know, if the courts themselves, you know, are supposed to be separated from the state. Once a case is in the courts, surely the courts are able to manage, you know, weak cases and say that those cases can't go ahead. You don't want to be taking people, you know, being under criminal prosecution, as I know, is a torturous thing. You don't want to be putting people through that if the case evidence is weak against them, if there's vexation or something like that. The courts can manage it. But the CPS keep wanting to come in. The state wants to put its arm in and stop these private citizens prosecuting. And there was in 1981, there was a Royal Commission on criminal procedure. And this is where the recommendation for the Crown Prosecution Service came from. Prior prosecution, obviously conducted by the police, and they introduced the Prosecution of Offenders Act 1985, and that brought about the Crown Prosecution Service. So it's quite extraordinary, you know, within my lifetime, this country didn't have its own prosecution service. Probably like to young people, they probably think it always existed. Well, it didn't. So what was going on before that? Well, you know, we were operating purely on this right, this constitutional right of prosecution that we all have. So Section 6, John's talked about it already, okay? The Prosecution of Offenders Act, and this is what the Gujarat case was all about. It was about whether this policy of the CPS, whether what they've implemented, because what it's saying here is that, yes, we can all start private prosecutions, but where the criminal proceedings are instituted in circumstances in which the director is not under duty to take over their conduct, he may nevertheless do at any stage. But Parliament was silent on what would he do with it when he did take over it. Now, clearly, in a society where we, you know, the CPS are all bona fide, acting honestly, you know, you've had, say, for example, difficulty with the police. The police won't prosecute for it. They won't hand the file over. You cannot go to the CPS and hand the material to the CPS and say, look, will you consider that? They won't take it from you. The only way to bring it to the CPS attention would be to start a private prosecution, to issue summons, and then notify the CPS that I've started this prosecution, here's all the evidence, you guys, you're professional, you're acting honestly, you're really good people, and you act for the public, run with it. Well, they don't do that either. What they're doing is coming along and taking over criminal cases which should be before a jury and trying to shut them down. That's what... Okay. So they introduced the policy. John's bullshit detector's just gone off. But the policy was they talked about the CPS. Of course, you can't argue with it. When the CPS came, it was a national body through England and Wales. You want uniformity within this body. So, of course, they've got to have some sort of policy for how they operate. So they introduced the evidential sufficiency test and the public interest test. Well, obviously, it's always been a matter of law that you have to have evidence to go to court. And, of course, public interest has always taken some part in that. But the evidential position that they've come up with is a realistic prospect of conviction. And I love all these, like, it's very airy-fairy, realistic. One realistic to one, not realistic to the other one. And it becomes ambiguous, so... Well, I don't think that case can go to court. I'm this prosecutor, but this one might think it needs to go to court, even when it blatantly ought to. But come to that. Duckenfield, John's talked about that. That private prosecutions. Now, this is, again, quite interesting. It's Duckenfield, which is Hillsborough, yeah? He was the chief of South Yorkshire Police, and this was about a private prosecution, the families, so this group, so, you know, yeah, it's history, again, a group got together to fund, again, I think it was Michael Mansfield, wasn't it? Got together to fund a private criminal prosecution of this top police officer, and he obviously challenged their right to do so, and it became Duckenfield, and yeah. So he was talking about the right for the CPS to come over and discontinue it, yeah, and but only if there was clearly no case to answer. But this is sort of developed from there. Sorry. That bit there, I'll read it out to you, because this was actually the letter. So in 2000, okay, CPS has been created in 1985. In 2000, Parliament hasn't said anything, but in 2000, the Director of the Public Prosecution said, where have we been asked to take over the prosecution in order to discontinue it? We would do so if one or more of the following circumstances applied. There is clearly no case to answer. Okay? A private prosecution commenced in these circumstances would be unfounded and would therefore be an abuse to bring a prosecution. So the CPS said, if the case is established, a case to answer, we won't touch it. Yeah, we will not touch it. But it changed. So in 2009, I understand the director changed to Keir Starmer. Someone should look into Keir Starmer. But it changed, and he made a change of policy stating that all private prosecutions, which they were asked to consider, because Parliament, you could start a prosecution, and the CPS will never come to find out about it. It will just go through the courts, unless someone tells the CPS about it, or it comes to their attention, and asks them, will you come and look at this case? So I start private prosecutions, and straight away the police are over to the CPS, will you have a look at this, please? Miss Doherty, will you give us the evidence? We'll have a look at it, and whatever. That's what they do. So he said that all prosecutions would have the full code test applied to them, this evidential sufficiency and public interest test. And that led to the Gujra case, which was decided on the 14th of November 2012, settled 3-2, but the two, Lord Mance and Lady Hale, are quite, you should go to the Supreme Court website, look at the judgments, it's very, very interesting to read. Lord Hale and Lady Hale and Lord Mance are very vociferous, their dissenting voices, about the emancipation of the right of private citizens access to the criminal courts, and that the rights, they talk about defendants' rights in the criminal courts. Lady Hale talks about the rights of the victim, yeah? And what she says is, if the CPS are really applying, because it became, through the court case, they talk about it's a 51% is a realistic prospect of conviction. So only cases that are going to be 51% likely to result in a conviction can go ahead. And as she rightly said, there's been a lot of work done in the last 30 years about sexual violence against women, children. Naturally, by the circumstances of those offences, the evidence can be weak in some areas, and those cases, they might be 30% likely to get convictions. Are they not going to go to court now? Are we going to stop all date rape cases and rape cases or whatever that people have done an awful lot of work to make sure they go to court? They're saying 51%, and we'll shut the cases down. So they've also raised human rights issues in the case, Articles 3 and 8, but Article 6, as I certainly think, is being activated, your right to a fair trial, because your right to a fair trial talks an awful lot about the fact of defendants' rights, your right to representation and stuff like that. But your rights, but also fair trial talks about your right to uphold your own rights. And I think if the criminal courts are removed from us, then the only remedy, that it's not a remedy, but if someone's done a criminal act towards you, you're not going to get remedy in a civil court. Public at large, okay, need the remedy that the criminal courts offer, which is, of course, conviction and possible jail terms or whatever sentences come with it. And it seems that they're trying to take this off us. But the Supreme Court has said that the CPS policy is lawful, currently as it stands. But it's a very weak judgment. My case is going to be the first... Okay. Yeah, my case is going to be the first to go into the High Court. So I've got a judicial review. In my case, the first private criminal prosecution I started in relation to the secretary of the commander, which is in Luton Crown Court. They decided to come along and try and shut down my case. Okay, and that's now was stayed pending the outcome in the Supreme Court, and my case is going to go before the High Court in the next few months, and all of these arguments will be played out, and obviously I'll be speaking to John about some other more interesting arguments that we're going to put into it. There are many grounds to challenge this decision. I would recommend you read the Supreme Court, because I think it's very, very important for all of us that we maintain our access to the criminal courts and that protect that right. But the Supreme Court has changed the decision. It appears that the policy for CPS is a realistic prospect of conviction, whereas the Supreme Court's now talking about a reasonable prospect of conviction, whatever that might mean. So hopefully the dissenting voices in Gujra will be amplified in my High Court case, which is coming very soon. So yeah. So in Article Right to a Fair Trial talks about in determination of his rights and obligations. Well, surely it's my right not to suffer criminal violation by the state. Surely. And how can I get any remedy if I'm not allowed access into the criminal courts, to a fair trial in the criminal courts, to have these things played out in front of a jury, in public? And I intended to yeah. What a lot of you are here for. You're concerned about corruption in the state, the way the state's behaving, the lack of accountability. Gujra was between two private individuals. It was an assault case between two people. There's very good evidence in it, but it was two private individuals. In my case, the defendant, because there's more than one private prosecution, is an agent of the state. So it raises a serious concern if the agent of the state have the ability to protect themselves from criminal prosecution. The way things are now, we don't trust government, and we don't trust the government bodies. We're surely, that's what's going to happen. And the more prosecutions, we're going to start seeing a pattern. They're going to come along and try and stop the cases, obviously. And I think if we allow this to happen, we're stepping further into this realm of state control. And if we go back to this what I said at the beginning here, is this country is a law of public prosecution, not of state control, not like other countries, and we don't want to let it go there. So, as John said in Guriat, the right to privately prosecute is a useful constitutional safeguard against capricious, corrupt, or unbiased failure or refusal of the authorities to prosecute offenders. And I think that's Lord Diplock, good old chap, if he's still around. Hear, hear. Starting a criminal prosecution. Okay, look, all prosecutions in England and Wales start in the magistrates' court with the laying of information. Information must be laid in writing before a court officer. You may be asked, you will be asked to take the stand, swear an oath, and lay that information. And it's deemed laid as soon as it's received in the clerk's office. So if they delay things, as soon as you've handed it into the clerk's office, which is important for summary offences, even if they don't consider it at that time. The information must describe the offence in ordinary language, identify the law or legislation that creates that law, and contain particulars that constitute the commission of the offence, the allegations you're making. And you can have more than one allegation. I'll come to it in a minute. I've got quite a handful of allegations in one of my criminal prosecutions. So, John said about the magistrates may issue a prosecution, and of course their discretion is very, very limited in this area. And I now know of a number of other people who've started or attempted to start private prosecutions, and they're getting massively blocked in different areas. But they're told all sorts of things by the judge, but their discretion is very, very limited. Now, if you take my email at the end, and I'm happy to send out a sort of pro forma of what I use and how it's all set out, yeah, and they pretty much can't do very much. But all you've got to establish is that it's an offence known to law, English law. that it's not out of time. So 6 months for a summary offence, so like common assault, you have to lay it within 6 months. If it's that the court has jurisdiction on the offence, that the informant has the necessary authority to prosecute. Well, we do, because we have a right to privately prosecute. And although in some cases, for example, we may need permission. For example, wasting police time needs the permission of the Director of Public Prosecutions. Otherwise, I'd be using it an awful lot. It's usually a live hearing, so my experience of it is, I'm doing it, so it's not theoretical. I go to the court, I ask to be put before the court. Usually they'll say, well, come back in, we'll give you a date to come back, and they'll give you a date in a couple of weeks, and you go back on an appointment and go before the court, and always, go on.
Sorry, the line, it's not out of time.
Yeah.
For a criminal offence, is there...
Yeah, on summary offences, so a summary offence, there is a time limit. But indictable offences or either way offences, there's no time limit. But certain offences, you need to look.
You said assault.
Common assault is summary only. John? 6 months. Yeah, 6 months, so common assault. But ABH, which is a triable either way, there's no time limit on it. But you have to just check. So, if it was out of time, you went there later. Just to give you a good example of it, Simon Harwood, if you might have heard the thing at the IPCC, they said, we're terribly sorry, our investigation ran over 6 months, so we can't even put him in court for common assault. Yeah? They could have laid information prior to the 6 months, carried on with their investigation, and then if they need be, brought him in for common assault for battering him with the thing. Of course, it was way more than common assault, but that was one of the things that they sort of excused themselves. That we can't even do that. So refusal, right? Some offences require the consent of the Attorney General. Some require the offences, but most of the ones you'll be dealing with, there's no requirement for consent. The DPP, like I said, wasting police time is one that you have to get the permission of the Director of Public Prosecutions, and I have asked him and got a refusal for a case of wasting police time. So if you don't establish a prima facie case, they can refuse to issue. And if the CPS is already prosecuting the case, clearly you can't have 2 cases running. The refusal should be exercised sparingly, only if the case is an affront to justice or undermines the rule of law. And that's from that case there, R.V. Milton Keynes magistrates. See, so there's been other people in there fighting, doing this themselves, yeah? But it's been sporadic, just a few people here and there. Building your case file up. Yeah, okay.
Like if the magistrates court, as they seem to be doing, ignore common law, as they seem to do quite often, how can you lay common law at their door and say there's something wrong here in common law terms?
Like, for example, I've got a case running with kidnap, which is a common law offence. They're not ignoring it. I mean, do you mean like that?
Yeah.
So I laid information for kidnap, common law offence of kidnap. So it's on my charge sheet, kidnap, common law. That the how this comes to being, and of course it's issued. No problem. I think I'll tell you about different blocking ways they're blocking things. What's happened to me? Some quite extraordinary one in Cambridge, but they are doing all sorts of things. I know one guy, they're running him around all sorts of different courts. He can't seem to get any purchase. They just really, and his case is something to do with council tax. They don't really want him in the courts doing this. So they're giving him a run around everywhere. Frightening him with certain things they're telling him. But I have every case I've gone to court to issue, they're all issued. I haven't had any problem, apart from Cambridge. So okay, you need to put your information. So when you're building up your case file, yeah, you want to put your information that you laid in the magistrate's court, case summary, okay, with numbered paragraphs about what this case is about, and your index of documents, including all your unused material, which I have to say I forgot in my first case. I don't know about that. I didn't have, but you have to obviously give them a list of unused material so they know what you've got and they can start to make disclosure requests from you and stuff. So witness statements, make them up, copy the police's. I mean, they've copied the police's. They're MG11. I have. I plagiarised their material. So you've got a witness statement of truth signed in the file of your witnesses to the case. So if someone has assaulted you, you might have a number of witnesses, put those witness statements into the case, and have all your case evidence that you have, CCTV, witness statements, officers' interviews, or whatever you might have, all tabbed out and listed with a case schedule at the front, and retain your unused material file. Okay. It's very easy. It really is very easy. Don't be frightened by it. Just get in there and do it. Summary offences must be laid within 6 months, or they're time barred. All summary offences heard, as you will probably know, in the magistrates' court, unless it's attached to an indictable offence. So then it can be transferred with the indictable offence and heard in the Crown Court, usually before 3 lay magistrates or a district judge. And as I say, beware of the court clerk. I've already told you about what happened to the court clerk in my case. He was an ex-police officer. Extraordinary. Either way offence is heard in the Crown Court or the Magistrates' Court. There's no time limits on either way offences. So like ABH is actual bodily harm is an either way offence. Decision on the venue is ultimately for the magistrates, who may decline jurisdiction on the case, depending on what the severity is. So we've had one private prosecution where this young girl has been assaulted, and we start this private prosecution, and because of this, the sort of background nature to the case, the jurisdiction was declined, and it's now gone to Guildford Crown Court. But both the defendant and the prosecutor can have their say about where. So if you're prosecuting, you'll decide, where do I want this case, and make your suggestions and your arguments to the court. Is where you may prefer it in front of a jury, and you might want to argue for that this case is severe and it needs to go before the Crown Court.
Question, please. Yes,
of course you can.
Does it cost?
I'll come to that in a bit.
Oh, right, okay.
Well, how much is your time?
Sorry?
How much is your time?
My time?
Yeah.
Very expensive.
Then it's very expensive.
I meant,
It's just your time. Yeah. Well,
does it pay the cost?
when I first went, my first private prosecution I started, which I tried to start in Brent Magistrates Court, HENDON Magistrates Court, and they told me, you've got to pay us £250. I said, no, I don't have to pay you anything. They said, you do. I said, go and get this a list or something that says I have to pay. So they came back with this green form, if you've ever been in a civil court, green form, and it says civil fees schedule. And I said, can you, not being impolite, but can you read this thing that says civil? This is criminal. She went, no, you're doing it yourself. It is civil. I said, no, it's not. It's criminal. There are no fees for criminal prosecutions. There's no fees, no nothing. It doesn't cost you a bean. Costs issues, well, the cost issues, possibly, but not. The problem with all of this is, like most things, it hasn't been done very often. So, ultimate outcomes, I'll talk to you about that in a second, okay? So, no time limit on how quickly. So, wrap it up.
Yeah, if you can.
I'll wrap it 5 minutes. Okay, 5-10 minutes. Yeah. So, indictable offences, no time limit. Must be sent to the Crown Court, Section 51 of the Crime Disorder Act. They've got no jurisdiction on it. My cases are all indictable offences. They've tried to argue to the magistrate, and I said, magistrate, you have no jurisdiction to even listen to him. You must send this to the Crown Court. They were saying, he's trying to do this and da-da. You can't throw this case out. I said, don't even listen to him. Just send it to the Crown Court. She said, Mr. Doherty, you're completely correct. And sent it off to the Crown Court. Case management will detail. Case management is cool. Go to the Crown Court. You're in there on your case management. The judge. I've got Lord Justice McCreath now in Southwark Crown Court, and they tell you what to do. By this time, do this, X, Y, Z. It's good. The case management. Don't worry about it. Get in there. And ultimately, you will have your case heard by a jury. But I haven't got there just yet. Yes. Yes, of course.
It's just on that point there about case management.
Yeah.
Feel you've got the experience or the wherewithal to put it together. Is there an agency you can go and speak to?
I think I speak on behalf of BCG, yes. We'll guide you. We'll cover you.
Sorry, can we get a mic there? Brilliant, thanks.
He's just saying that the BCG, if people wanting to start doing this, there'll be information put up and guide you through the process and stuff like that, yeah? I mean, there's plenty of criminal procedure books out there. There's Criminal Procedure Rules, 2012. Read them. It's all there on the internet, what you need to do. Okay, audience rights. I've got a difficulty right now, which I'm going to say to you, is in my case with 2 police officers for kidnap, false imprisonment, misconduct in public office, burglary, affray, and aggravated burglary, and actual bodily harm. Okay, I'm in front of Southwark Crown Court. Lord Justice McCreath has suggested, Mr. Doherty, why should you be allowed to conduct this thing? You're not a barrister. You don't have... I do have audience rights, but he suggests I don't have audience rights. And Archibald, 2012, section 229, it says the Crown Court has a discretion to allow a private individual to conduct a private prosecution before it, but it is likely that such discretion will be exercised only rarely. And as I've said to him, Lord Justice McCreath, if I don't do this prosecution against these police officers, this will not come to trial. The CPS won't do it, the police won't do it. Is that rare enough for you? But there's other arguments for it. So the 10th of December, I'm back in front of Lord Justice McCreath, and it's going to be very interesting, to say the least. The police officers have been called to come back. Disclosure, I really think this is really important. People have real difficulty with getting information out of these bodies. They won't give you anything, yeah, and you can't get purchase on what's going on. Criminal procedures. Now, I'll give you a really prime example which shows the IPCC and the whole lot of them for what they are. The 2 officers were ordered to be interviewed under criminal caution in relation to my case. When I got disclosure from the IPCC, there was only 1 record of interview, not the other officers. So I go for the Metropolitan Police, please give me these documents. No, we're not giving to him. Spring of this year, they said, if you want it, get a court order. So I didn't get a court order, I started a criminal court case. And then I got it. Now, if they're trying to hold on to something, you know, you bet your bottom dollar there's something really interesting in it. I'll leave it at that. Anyway, you can make application for evidence in the course of proceedings. You don't have to ask the court to do it for you, just ask them. Metropolitan Police, dear Commissioner, can I have all blah, blah, blah material, list it out what you want. Now, in the Met Police, they gave me some, and then they came back and said, when I said, you haven't satisfied the whole request, please give me the rest of the stuff, they came back to me, and this is in writing, we are now seeking legal advice from the CPS. The Metropolitan Police has a massive Department of Legal Services. They've got thousands of lawyers in there on massive whatever salaries in there, breast legal minds, and they're going to the independent supposed body for legal advice. They're ridiculous. It's ridiculous. But that's what they're doing. But they're trying to buy time. So if you refuse, you can make an application to the court. Ask for a case management hearing, go back before the court, ask the court, say, this is what I've done, asking for this information to be released. This is why I need this information for the prosecution, why it's relevant. Please order that they disclose this information to me. And you'll get, hopefully, your order for disclosure. So it's a valuable tool to get to the truth. And I like that John's touched on this, the fact that we can interview by post, yeah? Because this is something that I've already twigged on. And if you don't respond to that letter, your silence will speak volumes in the forthcoming trial. Yeah? Send them a letter. Tell them, I'm going to set out what you've done wrong. You've got the right to remain silent. Tell them, you've got the right to remain silent, but if you do, maybe use evidence against you, blah, blah, blah. And send them a letter. I've sent these letters already that I've formulated up. Yeah. Okay. Running the case. You know, sometimes in life you just got to get in there and do it. I'm not a lawyer. I'm an aircraft engineer. Just get in there and do it. And that is the key to all of this. If more of us start doing it, yeah, they're going to have to do it. They're going to have to sort it out. And the corruption is rife. There are so many people coming to me saying, look, could you do one for me? Could you run a prosecution? There is loads of injustice out there. And the only way injustice is going to get righted is if people start getting prosecuted in the criminal courts. And if those people are convicted, it sends a message out to the other people. And if you look on the police bulletin boards at the moment, they're talking about my case, and they're saying, it makes you think about what you're doing. And that's what you want them to do. And So, well, that's my judge. Okay, nice. I think, should we leave it at that, yeah? Oh, that's the prosecution that's going on at the moment, yeah? It's in Southwark Crown Court. It's very much in the media. It's kidnap, false imprisonment, burglary, assault, misconduct in public office, and affray. And, yeah, it's all good. So, yeah. Well, I don't know what they were, to be honest. Yeah, so I think there's lots of media out there, grassroots, all of you lot, thank you very much for your time and for coming today. Roger?